Welcome back. We're still talking about intellectual property, and we're starting with something that doesn't really exist anymore, the Yellow Pages. So this is an image of the Yellow Pages, and you can see that it is organized by category. This page in particular shows gardening centers, gardening designers, gardening equipment manufacturers, garden furniture, right? All of the categories are alphabetical, and then within that, you see that the listings are alphabetical. A yellow page, the Yellow Pages listed businesses. And every business you can see could either just have a listing of their name and address and phone number, or they could have an ad. And selling those ads was pretty lucrative. And that's what the parties are fighting over in Feist Publication versus Rural Telephone Service. Incidentally, one um, maybe unintended result of the way that Yellow Pages were organized was that there was a real incentive to name your business something that started with A, and sometimes you would see like AAA garden designers and then AAAA garden designers so that they would be listed at the very beginning of each category in the hopes that that would attract business because people looking for some kind of service would often go with the first listing in the Yellow Pages, or they would go with the biggest ad in the Yellow Pages. So this is a whole set of business that no longer really exists, but it's an interesting window into the way that things change and how businesses that seem very profitable can disappear in sort of a metaphorical blink of an eye. Okay, so Vice publication versus rural telephone service inquiry. Now, first of all, ask yourself what part of copyright are they fighting over? And in the elements for something that is a copyrightable work, it has to be an original work of authorship that is fixed in medium. And there's no question that a telephone book is a fixed medium. And what they're fighting over is really what does originality mean in terms of the requirement that in order to qualify for a copyright, you have to have an original work. So specifically what they're fighting over is the money from selling Yellow Page ads in directories. The way that this used to work is phone books would be passed out free of charge. And in fact, we see that rural telephone service is required as part of its grant of monopoly for telephone service in an area to produce a telephone book that it will pass out free of charge. The white pages have an alphabetical order of individual subscribers. Typically, it has the name of the subscriber, the address, and the phone number, so that anybody looking to call another person could open the phone book, go down, assuming they knew the person's last name, um, go search for the last name, and hope that it was their person, because there could be more than one person. Say the last name is Smith and the first name is John. There could be quite a few John Smiths. Or maybe you know John Smith's child. So you have to try to figure out which number is the right number. And you usually did that based on the address. Now, at the time, you used to be able to pay extra to have an unlisted number, but that's not relevant for this case. So, right, what they're fighting over again is the revenue from selling Yellow Page ads in these directories that are passed out for free that serve a clear function in terms of letting people use the telephones to call each other. So, what is the legal theory that rural telephone advances? Their theory is that the telephone book is a compilation of data and they have a copyright in that data, that Feist Publication approached them about licensing the data and rural telephone refused. And because they're arguing that they own the data, One of the rights that they're saying they have as part of owning that data is the right to refuse to allow somebody else to use it. And without permission, Rural Telephone is arguing that Feist cannot copy their data. So they're arguing that they are like Jacques, who has the right to refuse to participate in commerce with Steenberg, who wants to buy, beg, or convince to have the right to transport something across Jacques' land. Right? The court there came down very heavily on the right to refuse, the right to exclude. So here, Rural Telephone is arguing we have the right to exclude Feist publication from using our data. So why don't they win? Right? Seems like a pretty good argument. Well, a problem that they run into is that facts can't be copyrighted. Right? So they have no copyright in the names, address, and telephone numbers. All they can argue is that they have a copyright in the compilation of that factual data. And in order to have a copyright in that compilation of data, there has to be some originality in the way they have compiled the data. So in terms of defining originality, right, the first thing the court says is that original, as the term is used in the context of copyright, means only that the work was independently created by the author and that it possesses at least some minimal creativity. And that's why compilations of facts can be copyrighted. Because in making a compilation, the author decides which facts to include, how to organize or present those facts, and in fact curates those facts before presenting them to the public. So again, that's Rural Telephone's argument, is we have curated this information and presented it to the public. And the court in fact finds that Rural Telephone has a copyright in some parts of the phone book. Right? In fact, Feist concedes that because the introductory material and the original ads in the Yellow Pages, and maybe even the organization and categories for the Yellow Pages. Remember, we looked at it, right? There are headings of the different categories of information. There might even be a copyright in that. But that doesn't help Rural Telephone in this case. Right? Why not? The court says that Rural Telephone may have been the first to discover and report the names, towns, and telephone numbers of subscribers, but the data doesn't own its origin to Rural, right? That data exists before Rural makes the phone book. The point of the phone book is ease of use. It's not discovering new data. So there's no copyright in the data. And then the court says, by arranging subscribers alphabetically, Rural Telephone hasn't engaged in the kind of selection, coordination, curation, arrangement that would be original enough to create a copyright. Because the court says there's nothing remotely creative in producing an alphabetical list. Now, mind you, there's a lot of work involved. But the court says that's not the test. The test is not, did you put a lot of work in making something? And we saw this again in the Cheney brothers case as well, right? The test is not, did you put a lot of work in? The test is, do you have a protectable property right? And the court here, in fact, points out explicitly that the fruit of the compiler's labor being usable by others without compensation, meaning that Rural Telephone has no property right that extends to the listing of names in its phone book, that would require Feist to pay them and license their information and accept their refusal to license that information, the court says that is not an unforeseen byproduct of a statutory scheme. That's not like some, oh my goodness, surprise, but is instead the essence of copyright, is that we are defining in a copyright what rights the copyright holder has and doesn't have. And what that means is the limits of copyright are defined in the grant itself. And again, we're back to that tension between encouraging creative endeavors and preventing monopoly. And here again, the court saying that is a balance to be struck by the legislature, not by a court. We're going to go by the language of the grants. Okay, so let's test what this rule looks like. There are 3 hypotheticals in your book on page 231, and let's talk about them. Right? So the first one is as part of an outdoor competition, and I didn't put it in the slide because there wasn't room for it, but the competition is taking place in Nevada. A carves a large ice sculpture that resembles the Statue of Liberty. So the question is, would the creator be able to get a copyright? What that's really asking you is there enough originality here? Is there authorship? Is this fixed in a medium? And right, the fixed in a medium part, that's why the court says it's an ice sculpture and it's in Nevada, a place where presumably it's going to be warm enough that the ice is going to melt. But that is really a red herring because it's clear that by carving it in ice, even though the ice is going to eventually melt, it is being fixed in a medium. Being fixed in a medium does not require that it be there forever. It simply means that it be a thing in the world in some fashion, at least for a time. So this is actually a pretty easy question. A creates the statue himself, and even if it resembles the Statue of Liberty, you can have copyrights in things that resemble other things. And clearly, this has at least some creative spark, even if the level of creativity here isn't super high. Right? The Feist Court says that a work may be original even though it closely resembles other works, so long as the similarity is fortuitous and not the result of copying. And here there's nothing to suggest that A has in fact copied the Statue of Liberty, merely that it resembles it. And probably, right, any large statue of a woman, if particularly a woman holding a torch, is going to in some way resemble the Statue of Liberty, right? So the fact that the Statue of Liberty exists doesn't sort of clear the field for any other statue of a large woman holding a torch. So the answer to hypo A would be yes, this almost definitely would qualify for copyright. That's a really easy question. And I just want to emphasize, right, that in terms of a work of authorship, a statue is the type of sculptural work that is expressly listed in the statute as qualifying for protection under copyright law. And of course, as I already said, the sculpture is in fact fixed in a tangible medium of ice. Now, it's true that an ice sculpture outside in the Nevada sun is likely to melt, but fixation just requires that the work be sufficiently permanent or stable to permit it to be perceived for a period of more than transitory duration. Meaning it can't be like a split second kind of thing. It has to be there for long enough to actually look at it. All right, so let's talk about the second hypothetical. After the copyright term for a painting expires, B takes a photo of the painting, attempting to copy it as closely as possible. So as a general rule, almost all photographs will meet the originality requirement because the photographer has to make a series of creative choices, including lighting, size, angle, all kinds of things. But here, to the extent that B is trying to make an exact copy of the original, it likely would not satisfy the creativity requirement and therefore probably would not qualify as a work of art eligible for copyright. And again, that is because the the hypothetical tells you that B is here trying not to be creative, but to in fact reproduce exactly what already exists. What about hypothetical 3? This is probably the more interesting one. Using publicly available information, C draws a map of Florida, which it should say shows, apologize, that's a typo, which shows the location of the interstate highways, county seats, and state capitals. Now, this is a compilation. So this is the issue that is closest to Feist versus rural telephone. It is, analogous to the directory that was issued there. But here, C can probably obtain copyright protection because of the creativity in the selection, coordination, and arrangement of the information. It's all publicly available information, but there are lots of data that C might have selected to depict on the map, including bodies of water, county lines, railroad lines, airports, state parks, towns other than county seats, the capitals, etc. You can imagine a whole host of information that C could have chosen to include, but didn't choose to include. C's decision to use only 3 types of data thus is more creative than rural telephone, right? It is a deliberate curation of this information and therefore would probably qualify for copyright. So I wanted to show you what I meant by the curation involved in information in a map that would make it eligible for copyright. This is the front piece of my book, naming Gotham the villains, rogues, and heroes behind New York place names. And this map clearly qualifies for copyright protection. Not only is it highly idiosyncratic in what information it includes, obviously it includes all of the boroughs of New York, Manhattan, the Bronx, Queens, Brooklyn, Staten Island, and then New Jersey, but it also includes the roads, bridges, and parks, neighborhoods, and landmarks that are discussed in the book, including a couple of roads that are in gray. And then the font, the line style, the choice of colors, right? All of these things make this map distinctive in a fashion that is at least minimal creativity and is in fact significantly more than minimal creativity and would entitle it to copyright. So I just wanted to give you a concrete example of what we were talking about and why the answer to the third hypo on the prior slide would be yes, that C's map would be entitled to copyright protection. Okay, now let's talk about a really important case in the context of patenting, Diamond versus Chakrabarty. So what did Mr. Chakrabarty do? Right? He was a microbiologist who created a bacterium with novel plasmids. These are plasmids that contain proteins that can break down hydrocarbons. This is not property of any naturally occurring form of bacteria, and it's 1980. Genetic engineering is in its infancy. We're just learning how to add bits of DNA to bacteria and how to use that to sequence DNA. So Mr. Chakrabarty, right, has done something novel, and now he wants to patent it. So what rights is he claiming in his invention? He's got a bunch of claims. He has a process claim, right? He's claiming a patent in the method that he used to create the bacteria. He has a claim for the medium that the bacteria is suspended in, and then a claim for the bacteria itself. The patent office granted the first two. They granted the process claim and the claim for the medium, but they rejected the claim for the bacteria itself, saying you can't patent a living organism because a living organism, even with this kind of an amendment, is a product of nature and therefore is not patentable. And the Patent Appeals Board affirmed this on the ground that living organisms could not be patented. So when this comes to the Supreme Court, the court has to figure out whether or not Mr. Chakrabarty's microorganism constitutes a manufacture or composition of matter within the meaning of the statute. And let's just advance to the next slide and look at the statute, and then we'll talk about the rest of this case. So here is the language of the Patent Act that defines what is patentable. And it says whoever invents or discovers any new or useful process, machine, manufacture, or composition of matter, or any new or useful improvement thereof, may obtain a patent therefor. So the court says the issue is whether or not Mr. Chakrabarty's new bacterium constitutes a manufacture or composition of matter within the meaning of the statute. And the first thing they do is turn to a dictionary and say that according to the dictionary, manufacture means the production of articles from the use of raw or prepared materials by giving those materials new forms, qualities, properties, or combinations. And the court says this should be interpreted broadly. This idea of what is a manufacture should be interpreted broadly to include anything under the sun that is made by a person. And then with that in mind, they turn to this bacterium that Mr. Chakrabarty has produced and say, well, this is new. It has new properties. It has properties that are not found in nature that Mr. Chakrabarty added to this bacteria from raw or prepared materials, which gives the bacteria new qualities and properties, and therefore it is patentable. Now, one thing I want you to notice here is that the court is taking a very different approach to institutional capacity and capabilities than it did in the Cheney Brothers case or in the rural telephone case, right? In both of those cases, the court said it's not up to us as a court to be expanding beyond the express language of the statutes that create these intellectual property rights. Here, the court says, well, once Congress has created this definition and they use this word manufacture, it's up to us as a court to interpret what that means in a new context. So it's a very different vision of institutional capacity than the court was presenting in the other cases. Now, interestingly, right, the court is saying that patenting, right, will not stop or slow genetic research, right? So it's sort of one of the things that really struck me in this case, and I would like you to think about, is why is the court extending patent protection in this context when the point of patent protection is to promote the useful art and sciences, and the court seems to be saying that patents are not needed to promote this research. So that's really something to think about. And there's no right answer, but just think about how the court responds to the concerns raised by the Patent Office, and consider what it is that you think the court is balancing there. I mean, the rule is the rule, but in terms of understanding how the court got to the rule, I want you to spend a little bit of time thinking about that. And I would also like you to just take a minute or two and to consider whether, had the major questions doctrine been propounded before this case, do you think the Supreme Court would have invoked it here, saying that this is a major question of application of law to a new situation that the major questions doctrine would apply to? Again, there is no right answer because that didn't happen, but I would like you to think about it because we're going to be dealing with the major questions doctrine in all of the classes you take in law school for at least the foreseeable future, and it's worth thinking about how perhaps differently cases might have been decided had the court been willing to invoke this idea that Congress had to speak explicitly in a statute before a statute could cover something new that was a development of technology that did not exist when the statute was written, or whether courts can use their interpretive powers to apply existing statutes to new situations, and whether agencies can apply their existing powers to new situations. So that's it. I will see you next class, and have fun with intellectual property.